So I will just quickly let you know who we have here, and we are honored and delighted to have an esteemed panel that I think really covers a range of positions among stakeholders in this conversation. And I'll just quickly introduce them from my far right. The Honorable Paula Carey, the Chief Justice of the Trial Court. State Representative Byron Rushing, the Assistant Majority Leader in the Massachusetts House. Daniel Bennett, the Secretary of the Executive Office of Public Safety and Security. Rasan Hall is the Director of the Racial Justice Program at the American Civil Liberties Union of Massachusetts. And Megan Kenny, a doctoral student in clinical psychology at William James College in Newton, and founder of the Opioid Crisis and Advocacy Student Group. Welcome to all of you. This is the point in a program where sometimes to lighten the mood, I think a moderator offers some little moment of levity or humor, and I was thinking about that, and I asked my family about this idea, and they said to me, you know, criminal justice reform is really not that funny, and neither are you. So I took that advice to heart, and I think we'll just go right into the program. And so, Representative Rushing, you and your colleagues passed really the most sweeping piece of criminal justice legislation in several decades. I know you were pushing very hard in the House for this to happen, but I remember a conversation with you back in the early days of this process when you weren't altogether certain it would happen, that the outcome was by no means preordained. And as we saw in the video, there's been some reluctance in Massachusetts going back many years to tackle head-on some of the things that the bill does address. What changed?
That's a great question, but I do think in Greg's introduction, we really saw a lot of what changed. I mean, and I think the major thing that changed was that there was on one hand, we had a significant change in the judiciary, in the head of the judiciary, who was interested in this, and so we had a person in our Chief Justice who was willing to speak about these issues straight out, and also was interested. Before he made all those statements, of course, he talked to a lot of people, and so so on one hand, we had sort of the establishment, which we all represent, even the ACLU here, and
don't tell us on.
but we had just an incredible grassroots organizing that was going on throughout the state on not comprehensive criminal justice reform, but significant pieces of criminal justice reform, all seem to have their sort of grassroots bases. And what we had was organizations like Mass Inc. that were willing to allow them to come together and then support them when they did. And so what we had was and Lou Finfer and people like that led that bringing together of this whole variety of grassroots groups to start working on a kind of list of priorities. Every time they came to my office, I always asked them, okay, what's the top 7 things you want, right? And they had, of course, 50. And they were willing to participate in that discipline. And I think that those things really came together. I want to just mention the fact that you started in the movie. You started with Willie Horton, and that is absolutely the right place to start. I mean, one of the things that those of us who have been here, as some people, as our Southern relatives say to us, I've been here since dirt. Well, I've been in the legislature since dirt, and let me tell you that
sometimes they refer to people as graybeards, but I don't know where they get that idea from.
there is a whole generation, of course, in Massachusetts that has no idea how we ran prisons before the Willie Horton so-called incident, right? We have prisoners who used to be out on furlough. We have prisoners who were in the community and came back to prison every week, right? And that whole idea, which we have not had the courage to put in the bill yet, right? That's the next bill. So that the shift that we went through in this state was just the shift to the right in criminal justice was just incredibly dramatic. And so it took a considerable amount of time and energy and persistence to bring us to where we are now. So I think I want to just give that sense of all of the people and what that were involved in this, but how that involvement took shape and form by having them come together and be listened to.
Great. And so you talked in referencing the period of time when there were furloughs about people being in the community and coming back. I think, sadly, what we've seen all too much of is people who've been in the system coming back due to rearrest and reconviction. And so, the Council of State Governments, whose review kind of was the first leg of this reform effort, reported that 2/3 of those leaving houses of correction and over half of those leaving State Department of Correction facilities had some type of new involvement with the system within 3 years. And I think just by any reckoning, you'd have to say objectively those are the marks of a failed system, and it's why there's been continued effort to try to get our hands around that issue. And at the outset of the debate, Secretary Bennett, the governor, I think, identified recidivism as perhaps the chief problem plaguing the criminal justice system in the state. So how, in your view, will the two bills that he signed last month make a meaningful dent in those figures going forward?
I think one of the big things is getting people out earlier on parole. If you can have people out in the...
Yeah.
Sorry, that usually doesn't happen because I'm usually used to coaching youth football. But I think the fact that people are going to be getting out on parole rather than spending their last days inside the facilities should help with recidivism, because if your first step out of the prison system or the House of Correction system is without supervision, you're more likely to fail out there. If you get some supervision and some support, if you get programs that are going to help you put yourself back into society with someone to help you out there, you're less likely to get back into a life that's going to put you into an area where you're going to commit a crime. I think that's probably the best thing that comes out of the bill as far as recidivism is concerned. And I know that's one of the things that the governor was looking at that fit well into the programs that we started at DOC in the last 3 years.
And Rasan Hall, in your view on this question of recidivism, how far does the bill go toward dealing with it in the comprehensive way that you and the ACLU would like to see? What are the sort of high points of it, or what do you think are the challenges in terms of this question of not seeing this sort of cycle of people back?
One of the biggest concerns that we had in this process and about the bill from the outset was that it was focused exclusively, or at least the CSG process, on recidivism, as opposed to stemming the tide on the front end to limit the number of people who are coming into the system to begin with. When we looked at the CSG process, one of the more persuasive recommendations coming out was the type of supervision that people were supposed to be receiving, something that was responsive to their needs and to their risk level. And so they found through their research that there were a lot of people who had supervision that was not appropriate for their level of risk, meaning that they were a low-risk individual, but they had higher levels of supervision, which set them up for failure, and then that there were people who were higher risk that were being released with little to no supervision, which increased the likelihood of recidivism. And that wasn't as significant a portion of the reforms that were included. There was certainly some money put in early on in the CSG bill, or 874, that the governor introduced, but it wasn't a cornerstone. I think one of the other things that we were very concerned about in the beginning is, in the midst of this conversation about criminal law reform, and everybody is being celebrated for the great work that they've done, and certainly that is appropriate, that we cannot forget the lives that have been sacrificed on the altar of public safety, and the ways in which this system has over-incarcerated and oppressed people, particularly Black and Latino people and people in poor communities. And so the ideologies and the practices around how we incarcerate people, how we surveil their communities, and what type of treatment and services they get is informed through that lens of public safety and keeping people safe, when there is another reality or another version of public safety that can exist that does not rely on disproportionately putting people in cages. There is a harm reduction approach, there is a trauma-informed approach to dealing with issues of crime and criminality and recidivism. And I think that is something that has been missing in this conversation. And so we're hopeful that with the amount of data that is required in this bill, that it will better arm advocacy groups and organizations like Mass Inc. to provide an analysis to find out where we're going wrong, because it's been pointed out by Representative Rushing, and I believe you, Mike, that there has been this pattern and practice of how we have done things historically, because that's how we have done things. And we don't have any evidence that it's necessarily working, particularly when you look at the rise of incarceration rates, despite the fact that crime rates have gone down.
And I meant to mention this at the outset. There's just one little quick housekeeping note I was going to mention, which is that Secretary Bennett, who we're delighted to have here, has a very booked day, and my understanding is he's going to need to get to another event, so maybe leaving us a little bit early. So we just want to thank you ahead of time and let folks know that the Secretary will be leaving, but he's not going to be walking out at that point.
Exactly.
And so, Rasan, you mentioned this question of data and sort of having an understanding of how the system is treating people, the issue of disparities, who what is being done to whom and at what levels. And I think that really gets at one really critical part of the bill, and we're here to talk about making good on the promise of criminal justice reform. And a huge issue that has really bedeviled the state for decades has been the fragmented systems that we have, which lead to fragmented data collection or inaccessible databases. And that's something that the Council of State Governments report actually identified early on as a real deficiency here. And it's something that the final bigger bill that was signed by the governor looks to take on in a big way by making requirements for data collection, setting up an oversight board to look at that. And so I'd like to ask Chief Justice Carey to talk a little bit about the challenge of implementing this. It feels a little bit akin to kind of steering an ocean liner and getting it set on a new course with systems that have been so embedded across the state. But how big a challenge is that, and what do you see as the real promise of that in terms of what it could mean for our system going forward if done right?
We embrace the opportunity to get it right. Right now, some of our systems just don't talk to each other very well. I'm not a techie, at least in that regard, but I know that our technology folks have been meeting with the CJRC and meeting with EOPS really to try to rectify the situation. I think that the fingerprint identification it would go a long way in terms of making sure that we get it right. We have huge issues in the system with multiple aliases and different different names, different identities, and so using the fingerprint identification I think would help us. And we're anxious for the data. If you would have asked me 5 years ago, I think the trial court would have been a system that just doesn't use data. Data didn't inform the way we worked, but there's been a whole sea change in the trial court in terms of just the need for data with everything we do, and the need to get it right. We have restructured our organization so that we have performance analysts in each department that help make sure that our data is quality data as opposed to not quality data, because there are times when we run our reports now and you just take a look at it and you know it's wrong, because it's intuitively wrong when you run a report and find out that there's only three cases in our system where there's an on and after sentence. We know that's wrong. So it means we've got a data quality issue, and we're working very hard at ensuring that our data quality improves, but we want it, and we want to be able to talk to each other, because it's only then that it will help inform our decisions. With regard to in areas of disproportionality, the only way we're going to move the needle on that is to be able to run the data and get quality data. We know that there are varying points in our system where there's disproportionate impact. One area is in the area of specialty courts, where we know it's disproportionately white individuals who have the opportunity. We've had some researchers go in and try to figure out what the intersect points are for decision making in those specialty court systems, and we're hoping to be able to move the needle in that area as well. But the only way that we can really inform our decision making is with quality data. So we embrace it, and our teams working to try to improve our ability to talk to each other. And then in probation, we are just rolling out North Point, which interacts with our mass court system, which is a case management system for probation. I think it's going to put us light years ahead of where we are now. Right now, everything's paper, and it's absurd, and this will allow probation to better serve the needs of those individuals who are on probation. It will actually help us with reentry. We're hoping to have a much better ability to get into to either DOC or the houses of correction to help these individuals as they reenter.
And Secretary Bennett, she mentioned EOPS. I mean, there is going to be a big role for your agency in this new data era that the bill is bringing us into. Your boss, Governor Baker, is certainly a data guy, evidence guy, who often talks about relying on data to really inform the governing process. So what do you think are going to be the challenges in implementing this, and what is the promise for how this might improve the system? Both, I mean, I think as the Chief Justice said, there's kind of a need to get things right and accurate, and then maybe Representative Rushing you way, and there's also a justice component to it. So it's sort of making sure we have accurate data, but then using that to really as a check or a guardrail on ensuring that justice is really part of our criminal justice system.
Right. I think the most important thing right off the bat is the privacy of every individual who's in the system, and through DCJRC you have to make sure that the privacy is protected for all the records, because in our quest for making sure we have accurate data, you have to also understand that there are laws that protect all of our privacy. Now, the second part is making sure the data is accuracy, and as the Chief Justice pointed out, the fingerprint system, and making sure fingerprints are used rather than just people using names. You can have on a Board of Probation record, you can have 11 or 12 names that are popping up. You can have a lot of our police departments do not regularly fingerprint, and so you don't know whether it's accurate information about an individual, which is entirely unfair. And the third thing is transparency. There's been far too much that we've done in the system, including agencies I'm responsible for, which hasn't had enough transparency and the ability for outside public interest groups to access that data. So I think that's the three things we have to take care of. It does take money to do it, only because there's a limited number of personnel at EOPS. It's an agency that's designed to oversee other agencies. It's not an agency that's designed itself to do research.
So I would like to add to that of course, as we all recall from the CSG report, I mean, their criticism of our data collection was just over the. I mean, essentially they said we had no system, and I think that, and we were all surprised when the CSG bill came out and data wasn't in it, and so that meant there was somebody in that, was it the triumvirate, who made the decisions about what would be in the CSG bill, that didn't think it was that big a deal. There was at least one person that didn't think. Now, I don't know who that person was, right? But we were struck by that, that this very, very clear criticism with a group of clear recommendations for data collection. And I think that there is, and I think we should assume that there is still going to be resistance to do the data collection as we have outlined them in the bills. And so as you said, that I took the lead on that and getting that into the House bill. And of course, all I had to do was call up Mass Inc. And to make sure I had all my lines correct. Though I did learn one thing from a doctor in my local health center at the South End, who said you always have to remember that the plural of anecdote is not data. And that means that, and the reverse is true, and that is that there's a lot of people in this system that think that it's okay to run the system based and design the system based on anecdote and not what is happening to everybody. And so that is the position that we're in. One of the things that we did in trying to figure out how and how to go forward was to set up in the legislation an interagency working group on this, and we made sure that the chair of that group knew something about data. So the chair of the group doesn't represent any court system, and doesn't represent the sheriffs, any of that. Fortunately, our wonk governor had a new secretariat created on just that. What do you guys call it?
EOTS.
Right, and so now we have a secretary that is the whoops, where did I have? I had his title because it's so long. The secretary, the Executive Office of Technology Services and Security, right? And so we made him the chair. I think the governor knows that now, and you just appointing there's a new secretary coming in that has EOPS experience.
And
right.
he would be, it's easy for me to say because I worked with him for 3 years, but he's sort of the perfect person for this type of job. He worked developing the system, but he also, the transformation, working with the court system to try to get us online, and working with, he's a former person that worked inside the Department of Corrections, so he knows the flaws that come out of the DOC, and he was really chosen by the secretary that developed EOTS as the best person within the administration to take over. So, not that the governor doesn't decide, I'm not saying that, but he was the person that the secretary said would be the best person.
But Representative Rushing, I can assure you, the trial court, we are very committed to getting our data right and working collaboratively with the sheriffs, DOC, and EOPS to really be able to help inform decision-making through data.
And then just let me just say a word about privacy. Everything you said is absolutely correct. But at the same time, of course, all of you who know that in collecting all of this data, all of it can be made available in an anonymous fashion. And so the large numbers, what we learn and collect, can be provided in an anonymous fashion. And when it is in that form, it should be made public. Everybody should be able to. You shouldn't have to. You should not have to struggle to go find that, and you shouldn't have to sue anybody to find out those answers.
Megan, Kenny, let's talk a little bit about the issue of addiction, the opioid crisis. It feels like the questions around that and around drug offenses really loomed large over this criminal justice reform debate because the debate ended up, and the bill addressed specifically some drug charges, in particular eliminating some of the mandatory minimum sentences that have been in place for lower level drug distribution. There's also just as we hear from and have heard often from Sheriff Tompkins, a much bigger effect of substance use disorder and mental health issues on the criminal justice system. I know the sheriff has often said that over 70% of the folks housed in his facilities are suffering from one or often both of those, and many of them are not sentenced necessarily even on drug charges specifically, but those are the issues kind of upstream of what led them to be incarcerated. Now, and maybe talk a little bit, now this is an issue that I think you have at least 3 vantage points on, and so just talk a little bit about that, and there's been so much talk about trying to get our system to pivot from dealing with drug issues through the criminal justice system and through criminal sanctions to treating it as a public health issue and public health crisis. So how well do you think the bill is doing at pointing us in that direction, and what are the sort of challenges you see in terms of how it deals with the way the addiction issue intersects with criminal justice?
Sure. So the 3 vantage points for me really is not only am I studying to be a clinical psychologist now, but I do have the lived experience of what addiction can bring to not only an individual, but a family and a community. So I'm somebody in long-term recovery from opioid addiction. I'm also the child of somebody that struggled with addiction for years and rotated in and out of the criminal justice system. So I'm very well aware of what incarceration can do in terms of the collateral consequences that a family can experience. And I think for me, there needs to just be a clear distinction. Like when we look at the laws of, fentanyl and carfentanil trafficking, are we really targeting the folks who are making this product widely available and accessible in devastating communities, or are we focusing on people who are sick and in need of treatment? And as we know, there are a number of folks that rotate in and out of the system that struggle with mental illness and addiction. And luckily for me, I was somebody that got treatment when the time was right. I can't say that for a lot of my peers and for a lot of the folks in my community. And so for me, it's a really important piece to focus on the fact that jails are not treatment, and that in order to get people better, they really need to have their needs met. And we really can't be surprised either when people are active in their addiction and their mental illness is untreated, that they're engaging in really problematic behavior that ends up in a situation that's not only unsafe for them, but the people around them. And for me, the way that I rationalize that, and with my clinical expertise now in bridging those 2 worlds, it just makes sense. That's a function of the disorder. It's how the individual survives. It's how they maintain an everyday life. And so, we can't be surprised that people do what they do. We just need to be able to step in and do the right thing in order to prevent it from getting to that point and actually get them the help that they need. Because really, the bigger picture is that everybody benefits in the end. Excuse me.
And Rasan, how concerned are you about this? And I guess, but just for, I'm sure a lot of people here, followed the details of the bill closely, but I think what Megan's referring to is, although the bill removes several mandatory minimum drug sentences, it does add a couple of new mandatory sentences related to distribution of fentanyl and carfentanil, which the governor and members of the legislature have just identified as a, really sort of public health and public enemy number one really facing the state. And so there was a lot of, in some ways, I think people understood the move to do that, but it did seem to, in some ways, send sort of a mixed message. If the thrust of the bill was that mandatory sentences, especially related to drug crimes, are really not the best way to go at that issue, and that we really need to give judges discretion to really understand the circumstances of each case. And we now have, sort of, in this case, an example of moving sort of in the other direction. And so how concerned are you, Rasan, about how this will play out, whether, how prosecutors will use what's really now their discretion to charge people under these mandatory statutes?
We're very concerned. When the conversation about substance use disorder and the opioid crisis kind of reached a fever pitch, to a person, every elected official and law enforcement official was saying that this is a public health crisis and that we should treat it as such, and that we cannot arrest ourselves out of this crisis. But yet we still kind of double down on these same backwards practices, because if mandatory minimums worked, we wouldn't see the opioid crisis that we see. If mandatory minimums worked, we wouldn't see the gross racial disparities in black and brown people serving sentences, but still there is substance use disorder in those communities. So that model does not work. And the fact that there are still lengthy sentences on the books available to judges and for prosecutors to make recommendations for does not belie the fact that it can be addressed through the criminal legal system, but putting in place mandatory minimums is not helpful. And with the use or with the creation of these new mandatory minimums for synthetic opioids, particularly carfentanil, where it can be trafficking at any weight and carrying a 3-year mandatory minimum, one may say, well, there's a knowledge requirement in this new provision, so they'll have to prove that the individual who had this carfentanil had knowledge that the carfentanil was in there. But how then do we get around that? How do prosecutors then try to get around the knowledge requirement of the carfentanil piece? Well, the individual may have said, well, everybody knows that this stuff is laced with something. Is that enough? Does that meet the sufficiency requirements to make the prima facie case that there is enough for knowingly trafficking carfentanil? And again, you mentioned the role and power of prosecutors to make these arguments, to leverage guilty pleas against people. And the reason it's problematic with these mandatory minimums is because we have public health data that shows that people who suffer from opioid use disorder are 120 times more likely to die of an overdose upon release from incarceration as compared to the rest of the population. And so some may say, well, that's because they have more severe substance use disorder or more significant habits. I beg to differ on that because of what happens during incarceration. People are going cold turkey, but they're coming out without any treatment and going back to the same using habits and overdosing. And so this is not a model for success. Back in the streets, we talked about the kids who you would get to do the dumb stuff, and we'd call them crash test dummies. We're making ourselves out to be crash test dummies because we saw what mandatory minimums did to black and brown communities in the 80s with driving up the rates of incarceration and the racial disparities, but yet we have doubled down on it for these opioids and heroin, and it's just not going to serve us well.
So I want to turn to another topic and hopefully get Secretary Bennett's thoughts on this before he has to dash out. And that has to do with incarceration rates. Certainly, one goal of the broader bill that was passed was to try to reduce incarceration rates in the state, whether through lowering recidivism or seeing fewer people sentenced to incarceration for shorter durations. But while this debate has been playing out, something pretty striking has been taking place in the state, and that is that incarceration rates, in fact, have already been dropping, and they've dropped fairly precipitously over the last 5 or 6 years by roughly 20% in both the county systems and state facilities. And I know there's been a lot of efforts to try to tease out, you know, the factors behind that. I'm sure, as with many things, it's a lot of factors. There was, notwithstanding our talk about the resistance to change here, there was some changes in sentencing laws enacted in 2009. Maybe they're starting to play out to some degree in these figures. But I guess the question is, I mean, what do you see in that decline? And more specifically, there's been a lot of talk about this question of justice reinvestment, and that we need to ratchet back on corrections spending and try to see that those resources deployed in other ways that are more oriented toward keeping people and getting people onto a positive path. Yet we have not yet seen real reductions in correction spending. Should we be looking for that as these declines continue to sort of settle in, and what should we be thinking about doing in terms of redeploying resources?
Well, I'm just going to speak for the DOC right now rather than for Sheriff Tompkins. But we had a drop of 8% since the governor came in the DOC population. Yep, we had a drop of 8% since the governor came in the DOC population, and we cut our corrections officers by 15%. At a certain point, however, and we're asking for another class because we lose about 200 corrections officers a year, we're asking for another class because it'll yield 175 corrections officers. You start to see your overtime skyrocket because you have to have corrections officers, and you also have a safety issue where you're asking, you have to have the units watch in the tiers. You ask the corrections officers, you won't release them at the end of their shifts, and they have to work 16 hours in a row, which is not good for the inmates or the corrections officers or safety overall. We closed 2 of our prisons, and we shut down a lot of the units because with 8%. At a certain point, you don't get as much savings. I'm not going to say I have all the answers, but one of the answers that's clear when you look at the data is that our population is getting older, and younger men are more likely to commit crime than older men are. I was certainly more likely to punch somebody in the face when I was 26 than I now am when I'm 56, and that's actually accurate for what I did when I was 26. So I'm not going to, so that's what happens. Now, one of the cost increase that we have is our health insurance contract. We have a health insurance contract which covers everything, and we signed a new one with a new health insurance provider, and it costs over $30 million more than it did, and the reason for that is they have to pay the health of an older population. They're not looking at a lot of younger men, 24, 25. We have I don't want to be inaccurate here, we have a large group of men over the age of 70, and that's why it was so good that the legislature passed part of the bill as medical parole, because we have a lot of people over the age of 70, and they are getting massive amounts of treatment, and every time they go to the hospital, they have to have 2 corrections officers go with them. So the money will trickle down, but not as much as it would because it's going to be very difficult to close another prison since we've already closed 2.
And so you mentioned the question of younger offenders, and that's something that I'd like us to spend a couple minutes talking about here. As the CSG report showed, and studies across the country have shown, that population reoffends or recidivates at the highest rate of anyone in the system. And there's been a lot of talk about trying to zero in on that population. To put it crudely, I mean, we really will get the most bang for the buck if we can make real inroads in that population. There was in the debate on Beacon Hill some talk, and I believe in the Senate bill, talk of raising the age of jurisdiction of the adult courts to 19, taking stock of some of the research on younger offenders and this idea that they might be better served in the juvenile system. That didn't end up in the final bill, but the bill did set up a task force, and before everyone rolls their eyes about task forces, there's some hope that that really is going to have some traction. And I think part of the reason there's some hope for it is that the task force to look at this question of younger offenders, some of the optimism is the fact that at the county level already, there are sheriffs taking steps to deal with this. While the jurisdiction may not have changed from the adult to the juvenile system, there are a couple of sheriffs looking at setting up separate units for younger offenders that really focus much more strongly on rehabilitation, and within the adult system, I think sort of applying the focus and the philosophy behind the juvenile system to those offenders. And finally, a group of stakeholders from Massachusetts criminal justice world recently made a trip to Germany to look at their system for dealing with younger offenders, which is quite different than ours. And I know, Chief Justice Carey, you were on that trip. I just wonder if you could talk a little bit about what you were struck by there, and as different as the two countries are and and what they're dealing with, what are the lessons you think that might hold for us as we continue to explore this question here?
It was a fascinating trip. It was a whirlwind. It was a fascinating trip. It was a whirlwind. My office got a call from the Boston Globe the day before, and wanting to know about what was happening. And I said to my PIO, just show them the itinerary, which is crazy. But Germany is a very different society. They really don't have issues with guns, and I think if we could get rid of guns and the issues that we have with guns, it would be a very different system. And additionally, in terms of opioids, it really hasn't taken hold. The answer that I got when I asked the question about opioids in Germany was that their prescription practices are very different. In fact, they don't over prescribe. That was the answer. But what we saw was a very paternal, maternalistic approach towards young offenders, and they define young offenders up to at times 27. It's really 25, but there are times when they would keep someone in the juvenile system up to 27. What was most striking, we watched one trial, and a young man, it was a criminal offense. He had pulled out a gun. It was not a real gun, it was a starter gun, and he was under the influence of alcohol, and he turned and put the gun towards a victim. And the trial, he ended up getting, I believe, a fine of 200 or 300 euros, was ultimately the sentence. This young man did not have a lawyer. Their system is set up that only when there's a possibility of incarceration in a criminal case do you get a lawyer. So it was fascinating to watch in terms of how the system plays out. The judge did all of the questioning. The prosecution, frankly, just made a statement. Granted, there was a bit of a language barrier, but we did have some folks telling us, interpreting for us. But I think what I was struck in the prisons, I think the prison in Germany, in Berlin, was pretty bleak, but they still deal with things very differently. I was struck by the fact that there were a number of individuals who were seeking asylum, and frankly, they had significant language barriers that these young people just couldn't understand not only what we were saying, but couldn't understand what the prison folks were saying as well. We went to a prison in northern Germany, which was amazing. It was a facility that almost, if you weren't really looking, it looked like a college campus. It was idyllic. They had a farm. People walked around freely. Apparently, no one was really following them. They knew where they had to go. The sentences are relatively short. You can't be sentenced to a juvenile facility for greater than 10 years. And the average, Steve, was probably less than 2 years, I think, in terms of the average sentence. So it was quite low. and the recidivism rates are much, much lower than our recidivism rates in the United States. They had a young mothers unit where there were only 2 women in the unit. Their ratio of, and they don't really call them guards, but their ratio of guards to inmates was 1 to 1. And I asked one of the women, you know, where would you be but for being here? And she said, probably homeless, and I might not have my child. And essentially these they called them guards, but they really didn't function that way. They really functioned as mentors, teaching these women how to care for their children. When you walked in, the nursery, and they each child had their own nursery, looked like any nursery that any of you would decorate for your child. So it was quite eye-opening. They had metal shops and woodworking shops and, you know, all of the tools that you would have in any woodworking shop, and without any concern about the weapon at all. There was no, we actually had a group of inmates that not only cooked us lunch but served us lunch, and we were a bit struck by the fact that we had knives and forks and, you know, everything that goes along with it, and there was no concern by any of them. So there's much, in my view, that we can learn from them. I think a lot of it has to do with the programming that they have in there. They have significant programming. Their correctional officers have 2 years of training, 2 years, and it is a large piece of it is training in social work, and many of the corrections officers really viewed their role differently. And the last thing that I'll mention is relates to, and I asked the question, well, how do you feel about putting, you know, young people who are 16 years old with a 21 or a 22-year-old, you know, what, they looked at me like I had 5 heads. They said, why is that a problem? We don't consider that a problem. I still haven't quite wrapped my head around that because I do think it's somewhat of a problem. They tell me that they look at, or they told us that they just monitor the younger folks a little bit more closely to ensure that there's no issues, but they, to a person, did not see it as an issue, putting people, you know, together. So, you know, what have we learned? I think, you know, from the CSG, we got funded for the initial, it wasn't part of CSG, but it was a recommendation of CSG. So in the budget, there was some funding to probation. We've just awarded a contract so that we are working with this age group, with UTEC and Lowell. So it's going to be a close collaboration, and we're hoping to build a model so that we'll be able to deal with, because we can't ignore the brain development science because it's real. We know it's real. I mean, I can tell you when I brought the numbers with me in our district court and our BMC, 74.8% in age 18, and in age 19, 75.9% of individuals have either had a dismissal or a cough. So it's only about 25% that we've got those issues where it's a guilty finding, but you know, there's also criminal record ramifications, so I think the diversion efforts will help. In addition to that, we are looking at some other models in other states. We need to tweak there's one out in San Francisco, a young adult, emerging adult model, and we're looking into that model. There's some issues that I have with the model in that they are in many ways targeting low-risk offenders, and I think that's wrong. I think as far as low-risk offenders, over-supervision is not a good thing, so that we need to make sure that we don't over-supervise. And then lastly, we develop sentencing best practices, and when you asked Rashawn about issues, I think things have changed, or you asked Secretary Bennett, our judges are looking at conditions differently. We've done a lot of training with conditions. Judges will often say, well, tell me what works. And, you know, we've been training judges to only assign conditions if you intend to enforce them. And don't put a laundry list of 10 conditions when someone's invariably going to violate. And many of the people who are serving time, specifically at least in the houses of correction, are violations of probation. So if we can minimize the risk that someone's going to violate probation conditions, that they may help specifically in this young adult area because of the just the brain development and the stupidity at that age. You do things that, that an older person might not do.
So, Secretary Bennett, now I'm talking about the current one, not the 20-some-year-old who would punch someone more readily.
More readily.
I mean, as I said, there's been some movement at the county level. I believe up in Essex County, I know Sheriff Tompkins has been in discussions about this idea of a young offender unit. Is there a place for that as you see it in the state system? Again, the Chief Justice talked about these places looking like campuses, and I'm always struck by the fact that some of these folks going off to state or county facilities are going at the age when some of us have kids we're sending off to colleges, and we have 18 and 19-year-olds going into facilities that some people regard as kind of a school for criminal studies more than anything else. So is there something to be said for trying to think about this population differently within facilities?
I absolutely think there is. We tried to set up a young offenders unit up in Concord Medium, and to work actually with UTEC, which is a great organization out of Lowell. We couldn't find the young offenders in the department. We couldn't find the young offenders in the Department of Corrections who would be getting out of the DOC within a fashion where they would still be young offenders when they got out. Because unlike the houses of correction where you would get a sentence primarily, unless you had on and after, of 2.5 or less, if you're going into the Department of Corrections, you generally have gotten, as a young person, you generally are in there for a very serious offense, a sexual assault or a murder or some other crime of violence. So, or you've gotten a long sentence. You're not going in there at that age. You might be going in there for a shorter offense because you've had a string of historical offenses at a 7 or 8 B&Es, but you're not going into the Department of Corrections with 2 or 3 B&Es at age 21, 22. So we were unable to do that. That's not to say that we shouldn't continue to look at that, because it is it's a very good idea.
So I maybe want to just get one more question in, and just to give people a little warning, we will then open it up to questions, so get those ready. And it relates to this talk of diversion that the Chief Justice alluded to earlier. So that has been one of the provisions of the bill that got a lot of attention was the new ability for diversion for various categories of people, including eliminating the age limit on it. So now it's kind of the reverse of what we've been talking about. We're talking about the ability to divert not only younger offenders, but people across the age spectrum. I guess the question I wonder, since we're again here focused on making good on the promise of criminal justice reform, is to go from the 30,000-foot level down to the courtroom level. Do you feel, and do you think the judges across